Good morning. Welcome to this morning's webinar on what you need to know about truancy in Vermont schools, sponsored by Vermont Family Network. My name is Nancy Breiden. I'm the director of the Disability Law Project at Vermont Legal Aid. Vermont Legal Aid and the Disability Law Project, just as a little background, provides free legal representation to individuals with disabilities and their families in civil legal matters related to their disability. Part of our work, a good deal of our work, involves students who are receiving special education either under an IEP plan or under a 504 plan. We do not directly represent students in truancy cases. Those students are assigned an attorney from the Public Defender's Office, but as I'll explain as we get into the presentation, we sometimes can co-counsel with that attorney where there are special education or disability-related issues that are involved in the truancy. What we're going to do this morning is I'm going to give you a brief overview of the law and then talk a little bit about problems with implementation, interpretation of the law, and then talk a little bit about what people can expect in court processes involving truancy. One of the things we should talk about before we get going is why truancy is important, or looking at truancy is important. And it's been pretty well proven that truancy in early education can lead to dropout, an increased dropout rate later on in the higher grades, and then also that there's a significant correlation between dropping out of school and further problems in life, including involvement in crime and incarceration. So it's critical that we have a good and fair system for dealing with truancy in Vermont schools, and hopefully we'll all come away from this webinar today with a better understanding. So we'll go ahead with the slides now. So this is a basic law that a person having control of a child between the ages of 6 and 16 must make sure the child attends school. And you'll notice I've put control in quotation marks because as a parent of grown kids now, having control of your 16-year-old is kind of a matter of some elasticity. So that's the basic law. School under the law is defined as a public school, an approved or recognized independent school, approved education program, or a home study program. There are exceptions to the basic rule, so that a child who is mentally or physically unable to attend school is not required to attend. A child who has completed the 10th grade is not required to attend. A child who has been excused by the superintendent is not required to attend, but that excusal by the superintendent cannot be for more than 10 consecutive school days and can only be excused, the student can only be excused for certain reasons, emergencies, absence from town, and we'll talk a little bit later about what some of those exceptions are. The excuse must be in writing, and this is just another exception. It shouldn't be bulleted the way it is, but the child is enrolled in and attending an approved and accredited post-secondary school. So that's the general law with the exceptions. The law has been written pretty openly and vaguely, and that's deliberate because it was tailored to allow for interpretation and implementation at the local level, part of our local control philosophy around education in Vermont. And so it's anticipated that districts would create their own policy and further refine the policies even at the local school level. So the other big exception is that youth over the age of 16 are not required to be enrolled in school. But if they are enrolled in school, the same attendance rules apply. So the process basically is if an enrolled student fails to attend school, the school will notify the truant officer who is appointed by the school board. So the school notifies the truant officer and the superintendent. And again, if the child is excused or exempted from school attendance, or the teacher knows that the student is absent due to illness, then the referral to the truant officer probably won't happen. And now we start getting into some of the ambiguities. Some districts treat excused absences differently from unexcused absences. So an excused absence, as we mentioned earlier, may be an absence due to illness, a family emergency, or family vacation, religious observances. In this distinction between excused and unexcused absences is one of the areas where people can really, people who are living with difficult life circumstances can get hit hard in truancy proceedings, because there's a lot of absences that in theory should be excused, maybe due to consequences of domestic violence, just living in poverty, living with mental illness, and whether those excuses that are related to those conditions are excused or unexcused can make the difference about whether a student is referred for truancy or not. The distinction between excused and unexcused, if it's not set out specifically in the school policy, is made at the local level and interpretation by the local school administrator. So there can be a wide discrepancy on how different administrators are going to view different absences, whether they're going to be excused or unexcused. There's a strong school of thought that the school should err on the side of treating absences as excused, because once you start getting into unexcused absences that result in a referral to the court for truancy proceedings, there's some thinking that that's not a good way to use resources, but rather you should be addressing the problem early on and providing social services that can help address the circumstances that have led to the truancy that has been described as unexcused. Excuse me, the absence that's been described as inexcused. So once the referral to the truant officer is made, the officer investigates the cause of the student's not attending school. And if the truancy officer finds that the student's absence is without cause, then the truant officer gives written notice to the person who has control of the student. The truant officer also has the authority, as does the superintendent, to pick up and take to school any school-age student that they see who's just out in the town or who's not in school. And I don't know how often that happens. I know that I was on a school board for a period of time, and the superintendent of our supervisory union drove a motorcycle, and he actually would drive around town in his motorcycle and pick up kids who were truant, and the kids kind of enjoyed that. So a couple of different ways to approach this. So there are, as I mentioned, the school districts can come up with their own policies and are encouraged to come up with their own policies around truancy. So supervisory unions come up with policies, and then even local schools within the supervisory union come up with their policies. And some of the differences in policies might include the number of absences before a student is referred to the state's attorney for possible prosecution, the number of letters the school will send to a family before a student is referred to the state's attorney for possible prosecution, and as I mentioned, the definition of excused and unexcused absence. Another big difference might be the availability and the scope of any pre-court intervention programs or protocol. Again, this can lead to real inconsistencies and unfairness across the state. So behavior that would lead to court involvement in one district does not in another, and even within the same school supervisory union or district, different policies will be applied. Sometimes it just depends also on the relationship between the family and the school. Can have a big impact on when students are referred for truancy prosecution. So one of the things that families should do is check your school's website and the student manual to see what your school's attendance and truancy policies are. Find out how your school defines excused and unexcused absences. Find out how to submit an explanation of an unexcused absence. Does the explanation need to be in writing, or can you call the school? Do you need a letter from a child's doctor if you're saying that your child is absent due to an illness? What documentation do they need? One of the things that that's been reported is in districts where there's not a distinction made between excused and unexcused absences, where they're all where the school district says just any absence, whether it's excused or unexcused, is going to count towards the number of absences that are needed before there's a referral. Some districts find that that is helpful in that it takes the guesswork away from administrators making judgments about whether an absence has been excused or unexcused. But it's important to find out what the policy around excused and unexcused absences is in your school, and what kind of documentation you're going to need to make an absence excused. So because there was a lot of concern around rising rates of truancy and dropouts, there was a report, some research done on a report issued by the Commissioner's Office by the Commissioner of Education back in 2009, and it set a recommended standard for referrals for prosecution for truancy. And this was just a recommendation, and the commissioner made the decision also that there couldn't be one statewide policy, basically because of the differences in various counties on what their ability might be to actually prosecute prosecution cases. So some of those differences might be the availability of local services for families who are facing truancy situations, what the state's attorney's caseloads were, what the judicial caseloads are, and what DCF caseloads are. So while they couldn't come up with a statewide policy, the commissioner did issue some guidelines, and those were, so they've recommended referral to the state's attorney's office after no more than 10 unexcused absences. And then if both excused and unexcused absences were used as the basis for truancy, the referral to the state's attorney's office should happen after no more than 18 to 20 absences. I think also a part of this recommendation was a shift in focus to early years, to truancy in elementary schools rather than middle and high schools, because the absence of engagement in education early on had this direct link to increased rate of dropout in the later years. So that more focus was going to be paid after, or the recommendation that was that more focus be paid on truancy in the elementary school years. Despite the commissioner's recommendation on the number of absences before a student is referred to the state's attorney's office for possible prosecution, the number of absences is still inconsistent across the state, and even when schools are in the same district. The differences in the number of absences before a student is referred range from referral to state's attorney after 3 to 5 unexcused absences to referral to the state's attorney only after more than 10 unexcused absences. The number of unexcused absences, or actually unexcused or excused absences allowed by a school before a student is referred for truancy, is important because it defines the amount of time parents may have to work with the school to address attendance problems before court involvement. So again, it's important to check your school's website and student manual to see how many absences are allowed before the school makes a referral for truancy. Another thing that you might want to do is, if you're recognizing that chronic absenteeism is a problem with your child, you should start looking at the issue of disability. The earlier you raise the issue of the impact disability may be having on the students' school attendance, the better off you're going to be, the more chance you're going to have to try to address what those issues are and get them resolved before there's a referral for truancy. And again, some of the reasons for causes for absenteeism might be mental health concerns, both of the student or in the family, domestic violence, poverty, homelessness, and of course the current opioid crisis. And as I mentioned, whoops, that didn't advance. There we go. So I mentioned earlier different truancy prevention protocols exist around the state to promote school attendance before the initiation of court action. Such a protocol might include phone call or visit from the school or a truant officer, referral to community services to help the student get to school, a letter from the school describing what will happen if there are further absences, meeting with the student, parents, and school to develop a plan to improve attendance, documentation of the student's mental and physical ability to attend school, a referral to the Department for Children and Families, and then finally referral to the state's attorney's office. And school districts and supervisory unions that have used some of these protocols have seen a definite decrease in the referrals for truancy. So there is a direct relationship between using some of these protocols and keeping kids in school. So I'd referenced earlier the possible link between absenteeism and disability. So again, absenteeism may be a sign that the school is not meeting your child's education needs. So getting those needs addressed through an IEP or 504 plan might help them achieve better attendance. So if your child or the student has a disability, or you think the student might have a disability that is getting in the way of them attending or learning in school, you should talk about the disability with the school early in the process. Really, when you recognize that your child is having attendance problems, you should really start thinking about this as a possibility. If your child is already on an IEP or 504 plan and the plan does not address absenteeism, the school may not be meeting its requirements under the law, and you should ask for an IEP or 504 meeting so the plan can be changed to address your child's absenteeism. We've had, in our practice, had families get help with having somebody come to the house in the morning and do an evaluation of what the problems are with getting the student out the door in the morning, and make a plan based around what those issues are, just trying to get a child out of school, out of the house in the morning. And I know that's can be a big problem. So going more on to the process here, if an informal effort to address truancy or if informal efforts to address truancy are unsuccessful, the student may be referred to the state's attorney's office as a child in need of care or supervision, or CHINS. Again, if those protocols, some of those steps in the protocols that were in the previous slide aren't successful, this is where you may end up heading. So the best way to avoid a CHINS proceeding is to address the child's absences before they become habitual. So this is getting back to the legal definition of what a child in need of supervision is. It's a child who either has been abandoned or abused by a parent, guardian, or custodian, is without proper parental care or subsistence, education, medical, or other care necessary for his or her well-being, is without or beyond the control of his or her parent, guardian, or custodian, or is habitually and without justification truant from compulsory school attendance. And obviously it could be a combination of any of these four items. but in this presentation, I'm just talking about the fourth bullet, is the student who is habitually and without justification truant from school attendance. So something that we don't see in Vermont, I'm not sure if it's ever happened, is that a person who has control of a student who is habitually and without justification truant may be fined up to $1,000. So there's that's considered a criminal prosecution for truancy rather than a juvenile delinquent prosecution. And a bill was introduced in the legislature last year that would increase that fine to $2,000. I'm not sure what the motivation for that was, since this is a provision that is rarely enforced, but there it is. The bill didn't go anywhere, but I think this was Senator Sears introduced this provision. So it's there and could be enacted on. So when prosecuting a truancy case, the state's attorney has to prove two things. The state's attorney has to prove that the student is habitually absent from school and that the absences were without justification. And there's no definition of habitually or without justification in the statute. Courts have interpreted habitually as missing 6.5 days of unjustified absence in a 4-month period, plus other excused absences, as 14 days of unjustified absences in a 2-month period, or 28 unjustified absences in 62 school days, which is about 3 months. So as you can see, it's all over the place. And those interpretations are not just in Vermont. Those are ones that are from other states as well. So to avoid, again, to avoid a referral for truancy, it'd be important to try to provide a justification for any absences that you can. And this would also help if you are referred to the state's attorney and the state's attorney has to prove that there were unjustified absences. In order to kind of defeat that, you want to provide a justification for any absences you can. And that you can do that by calling the school. Again, we said find out what the policy is at your school, whether just a phone call will work to categorize an absence as an excused absence, or whether you need a note from either the parent or guardian or the doctor. So again, try to communicate with the school, and if your student's going to be out, and provide an explanation for why they're out. So if a student, this is a case that we actually were involved with, if a student is in school and the school requests that the parent remove the student from the school before the end of the school day due to disability-related behavior, is this an unexcused absence without justification? So this is the situation where a student comes to school in the morning, gets dropped off by the parent, and then encounters some difficulty in school that's related to the disability. Maybe it's an anxiety-related disability or something along those lines, and the school requests that the parent come and take the student home. Does that count as an unexcused absence without justification for purposes of truancy? So in Vermont, one court has ruled that this is not an unexcused absence without justification. The court said the school's dismissal of a student before completion of the school day due to the child's conduct, when the conduct was due in substantial part to a documented disability, cannot properly be considered an unexcused absence without justification. And I think this is something that we get a lot of calls about, so I think it does happen a lot. Schools are calling parents and saying your child is out of control, come get them. And it's part of this kind of push out thing that we see nationwide, and at least in Vermont, that's been determined that that does not count as an unexcused absence without justification. I think in this particular case, the student had the maybe 19 absences, of which I think 10, I'm not remembering, were instances, or maybe it was more than 10 instances, where the school had requested that the parent come and pick up the kid, and then the parent was charged with a student needing supervision as a child in need of supervision. Likewise, a school suspension cannot be considered an unexcused absence. There's an exception to that where the conditions of the suspension or expulsion include a recommendation or a requirement that student participate in a program in the school or an alternative program outside of the school. So this next slide is what to expect once there has been a referral to the state's attorney's office. You're entitled to a notice and an opportunity to tell the judge your side of the story. The court will automatically appoint a lawyer to represent the student, and that lawyer will be appointed through the public defender's office. Parents also have the right to have a lawyer appointed, but the court may not do that automatically. So as a parent, if you're involved in one of these proceedings and you want to have a lawyer, you probably are going to need to ask the court to appoint you a lawyer. The court will also appoint a guardian ad litem to look out for the student's best interest. The guardian ad litem is just a guardian for purposes of the proceeding. It's not a guardian who has general guardianship powers like a parent does. And the guardian would investigate the causes for the absenteeism, maybe hopefully spend time with the student, talk to the family, talk to the teachers, visit the school, and find out, make sure that he or she gets all the information about the student's circumstances, any health conditions, any possible disability that may be interfering with the student's ability to attend school. And the guardian's role is to look out for the student's best interest. So it's important for the attorney representing the child to know about any factors that may be affecting the student's ability to attend school. So it's really important to let the lawyer know if you think your child has or may have a disability that is getting in the way of their attending school. Lawyers in truancy cases may not be familiar with laws relating to education for students with disabilities. So we frequently will get calls from either families or actually the lawyers that have been appointed to represent them to give them some assistance on the disability or the special education part of what's happening in the truancy proceeding. There was a project done in I think it was somewhere in maybe it was Washington D.C. where there was the person who organized this project had a perspective that behind every truant child there's a failed IEP. So his view was that if a kid is out of school, it's because they have an identified or unidentified disability, and the school isn't providing the necessary supports to keep the student in school. And so this particular attorney organized a project where they trained all of the attorneys who represented students in truancy cases, trained them all on special education law, and all of those cases got taken to due process hearings in addition to the truancy case and juvenile proceedings. And because there were so many of these cases going to due process, the school district attorneys were absolutely swamped, and the truancy lawyer, special education lawyers almost always won, and it was in their interest. This worked for them because in that particular jurisdiction, lawyers representing kids in truancy cases got paid a flat fee. They couldn't bill, maybe it was an hourly flat fee, but they couldn't make much money doing this. And so if they took a case to a special education due process hearing, they could earn attorney's fees. So it was kind of a win-win for the student and for the student's lawyer. We can't do something like that in Vermont because our attorneys representing juveniles in truancy cases get paid a different way. So there's really not, nor is there capacity in our public defender system to have all the public defenders all of a sudden learning special education law. But the Disability Law Project can get involved and help the public defender make arguments to the court about how the student's disability is getting in the way of their attending school, and how to make sure the school meets its requirements under the law, and that would hopefully address the student's absenteeism. Nope. So when you get a lawyer in your truancy case, these are some tips for working with your lawyer. Be honest and open with the lawyer. You need to know that what you say to your lawyer is confidential. Your lawyer may not tell others what you say to him or her without your permission. Sometimes you're not able to meet with your lawyer until shortly before a hearing. As I said, it's usually public defenders that are representing in these cases, and they have huge caseloads, and I know people get really frustrated with them. You just need to kind of be diligent and trying to get in touch with them, and know that they will pay attention to you. If you don't understand something that your lawyer is saying or that's happening in court, it's really important to ask. And then also just make sure your lawyer knows how to contact you. So these are the levels of hearings in a truancy proceeding. And I'm going to describe what happens at each of these as we go on in the slides. There's a preliminary hearing, and then status conferences, which are sometimes called pretrial hearings. There's a merits hearing, and there's a disposition hearing. So the preliminary hearing is the first hearing, and basically at this hearing the judge just wants to find out what everybody's positions are. So they'll ask whether you agree or disagree that the student has been habitually and without justification absent from school. So it's just kind of a let's get organized hearing. And then the next hearings are these status conferences, and there probably will be several status conferences, and these are held over time to keep the court informed of how attempts to resolve the case are proceeding. It's important to show up and stay engaged in working towards a solution to absenteeism. I must say most cases that do get referred for truancy get resolved somewhere in this status conference stage. Very few cases go on to the full merits hearing. So this may go on over a fairly long period of time, and as both the family and the state's attorney and the attorney representing the student and the student themselves try to figure out how to resolve the case. Again, it's important to show up at these status conferences and to stay engaged in the process of trying to come to a resolution. So if a case does get to a merits hearing, that's where the state's attorney has to prove that the student was habitually and without justification absent from school. Again, going back to having those notes or other documentation, notes from home or notes from the doctor, having that justification for absence from school. This is also where you'd argue that the student's not getting what he or she needs in school, and that therefore that they're justified for being absent from school. The school's not meeting their needs. So witnesses may be called to testify, and other evidence may be presented to the judge, and then following the judge hearing all of this evidence and reading whatever he or she needs to read, the judge will decide whether your child is a child in need of supervision based on the evidence presented. As I said, very few truancy cases go to a merits hearing. Most cases are resolved through agreements worked out before the hearing. if the judge decides that your child is in need of supervision, the Department for Children and Families prepares a plan of services called a disposition case plan. And this plan describes what needs to happen to address the truancy issues that brought the case to court in the first place. And then there's the disposition hearing, and at the disposition hearing, you let the court know whether you agree or disagree with the disposition case plan. And if you disagree with the case plan, then the court will schedule another hearing to contest the case plan. If you do get this far and there is a disposition case plan in place, it is important that you follow it. Very few cases, as I said, very few cases actually get to a merits hearing, and I'm not aware of any case where just a standing alone truancy issues resulted in a child being placed in DCF custody. You know, there may be truancy with other issues involved that result in a placement with DCF, but very few cases. I don't know of any cases where just a truancy issue lands a child in DCF custody. So as I said, the Disability Law Project of Vermont Legal Aid may be able to assist in truancy proceedings involving students with disabilities, and people who want to talk to the Disability Law Project can contact us in a variety of ways, and those ways are shown on this final slide here. So let me see if there are any questions. So there's a question about what an unexcused absence is, whether it's one day. Yes, each day absent is counted as an unexcused absence. There's a question about whether schools with tougher attendance policies experience less truancy, and there is evidence to suggest that that is in fact true, or at least where truancy is treated very seriously, both by the school and by the courts. And it sounds a bit harsh, but I think what's important is consistent enforcement of truancy policies and letting families and students know that this is very serious. Where you get into trouble is where if people start being inconsistent in the application of the attendance policy, then there's a lot more wiggle room and there's a lot more judgment calls possible, and it just isn't as fair. So from what the research that I've seen based on some of the truancy projects that have been in existence around the state of Vermont, where tougher and consistent application of attendance policies has been enforced, truancy has decreased. So there's some questions about statistics, and I don't have the statistics with me. I can get some. There has been some gathering of data, and I can provide that later on. But it's too much in the weeds to have done in this kind of a presentation. So there's a question about whether there wouldn't it be easier if there was a consistent set of rules across the state, and I think the answer to that is, in theory, yes, but I think the problem is the capacity. Different counties have different capacity to enforce rules. So what may work for a threshold of referral to state's attorney for truancy in one county would not work in another county. And that's why I think the Agency of Education would like to have a statewide policy, but they've gotten a lot of pushback or a lot of feedback from counties, including state's attorneys and DCF and people managing the court dockets, that if everybody has a threshold of 5 unexcused absences, in places where that would result in a huge number of referrals, those counties, the systems that have to deal with those referrals wouldn't be able to deal with them. They just would be swamped. So that's the hitch with trying to have a consistent set of rules across the state. I don't think that anybody's given up on having one, but they need to get more information and really be very thoughtful about how they come up with whatever that set of rules is going to be. I'm looking at the other questions. There's a question about a model of recommended definitions of excused versus unexcused absences. I'm not sure if there's a model, but I do think that this is an area where consistency would be good. And I probably didn't explain it very clearly, but one of the places, so Burlington had a big truancy project. And in that project, they did not make a difference between excused and unexcused absences. And I think the threshold was pretty high. I think you didn't get a referral until after 18 or 20. I can't remember how many absences it was. But people involved in that project, and I think this included families and the social workers and case managers that were involved, thought that not having a distinction between excused and unexcused absences was a positive thing, which didn't seem to make sense to me at first until I read what they had to say. And what was positive about it was it takes away the ability of a school administrator or teacher, whoever, to make a decision about whether an absence is excused or unexcused. So it's just a much more objective way of looking at things, and it seemed to work better. It worked better for families, and it worked better for administrators. So that was one perspective. I think that coming up with a list of excused versus unexcused absences, we're never going to be able to come up with a list that's exhaustive. You know, people's life circumstances are so variable, and you know, some new reason comes and people don't know whether to put it in the excused or unexcused column. So there is an argument for not making any distinction. There's a question about discussing how schools define an unexcused absence. I think it's all over the place, and that's why I encourage people to look at their school policies, either in the policy manual or the student manual. Find out what your school, how they defined, if they do define excused and unexcused absences. So I think that's... There's a question about supports that can be put into place during status hearings that weren't possible before, and I'm not sure what that might be referring to. There is some support for parents maybe that have communication issues. There's the Vermont Communication Support Project, and parents are entitled to accommodations that may be needed in a court process due to their own disability. They're certainly entitled to language interpreters if English isn't their primary language. So I'm not sure if those are the kinds of supports that the questioner was asking about. There's a good comment here that educational support team EST plans can be another effective tool in bringing a team together with families even if the child does not have a disability. So that's a very good point. Thank you. There's a question about what percent of truancy cases are related to disability, either defined or undefined, and I don't have, I may be able to find some statistics for that. I don't have any at my fingertips, no. There's a question about whether you'll have access to the presentation for download, and I'm going to read a little notice about that at the very end here. Yes, it will be available on the VFN website and on its YouTube channel. So when we wrap up, I'll give you that information. What's a question about what kind of training do school administrators get regarding truancy? I don't know the answer to that. You know, I mean, that's part of a, it raises us an observation, reminds me of an observation that we have generally about issues that we encounter in schools in our practice around special education issues. And a lot of the things we encounter are not the result of school personnel acting badly. They're the result of lack of training around issues. And, you know, I think that training would be important for administrators. So, you know, that's just kind of a more global statement. I think that's the end of the questions. Thank you for joining us for today's webinar. Please visit Vermont Family Network's website at vermontfamilynetwork.org for helpful resources, upcoming webinars, and other workshops and events. This webinar will be archived along with all of our other webinars and can be viewed on Vermont Family Network's YouTube channel. If you would like to talk with someone at VFN, please call 1-800-800-4005. Have a good day.